is that covering up this story about Stormy Daniels, keeping it from coming out, they felt could have potentially impacted the results of that 2016 election. So, more than just the falsification of documents, they felt that it really could have had an impact on him being elected into office, that that's what he was worried about. That's why he wanted to keep Stormy Daniels quiet. And sitting in that courtroom, the prosecution really put on a very, very strong case before that jury, where they made the really grave decision of convicting the first former president. They now have watched him be elected into office, and we are finally going to get to see this sentencing on January 10th. The judge has now decided to move forward with it. A lot of legal experts thought that this might get postponed until after Trump's presidency. Another significant thing to mention is that once Trump has been sentenced, he can then appeal this conviction. So something that could have happened if this got delayed even more is that Trump would have just been left with this hanging over his head while president as a convicted felon. He will now have whatever this sentence is, but he will be able to then move forward with that appeal process.
Katrina, stand by for us if you can as we continue to cover this breaking news. Let's bring in CBS News legal contributor and Loyola Law School professor Jessica Levinson. Jessica, your reaction to this breaking news. It looks like we lost Jessica's shot. Let's go ahead and see. In fact, I'm going to read a little bit of the conclusion of this motion from the judge, if we can see if we can get Jessica back. Part of it reads, therefore, the court finds that nearly the vacatur of the jury's verdicts nor dismissal of the indictment are required by the presidential immunity doctrine, the Presidential Transition Act, or the Supremacy Clause. So in conclusion, the judge is saying that neither the jury's verdict, the guilty verdict, or the dismissal of the indictment are required by the Presidential Immunity Doctrine, which is the Supreme Court case. Do we have Jessica back? All right, Katrina, let's go back to you. And if you can help us dissect the importance of one of those final clauses there in that conclusion from the judge.
I apologize, I missed what you were saying just there.
It's on page 18, the top part of conclusion, where it says, therefore, this court finds that nearly the vacatur, I'm guessing the vacating of the jury's verdict, nor dismissal of the indictment are required by the Presidential Immunity Doctrine, the Presidential Transition Act, or the Supremacy Clause. Can you translate that for us?
Absolutely. So part of the argument here is that there would be too much of an undue burden on Trump as he was in this transition period, as he entered the presidency, by having this sentencing take place. So they've been saying that it would go against policy, that it would be unconstitutional in the burden that it would place on Trump, Judge Merchan, and also that it would violate the presidential immunity ruling. But Judge Merchan has decided that this is not the case, that he is going to move forward with the sentencing before Trump's inauguration into office.
And just for everybody at home as well, as I continue to read this, so I had mentioned that Katrina had mentioned this, and I reiterated it, that Trump can either appear at sentencing in person or virtually, and that counsel is directed to inform the court of his preference no later than January 5th, 2025. Do we expect any other kind of legal challenge, Katrina, to this that could potentially push this back?
I mean, knowing Trump's legal team, there is always a challenge. So I would absolutely anticipate that they will try to push the sentencing. It has been pushed numerous times already. But given the fact that this is now bumping up on Trump's inauguration on January 20th, Judge Merchan has made this decision that he wants to move forward with the sentencing. And I would highly anticipate that we can expect this date to now stay in place.
So I want to go ahead, and of course, this information, Katrina, is coming fast and furious, as you very well know. But our colleague Graham Cates had sent an email out noting one particular passage that I'm going to go ahead and read. While this court, as a matter of law, must not make any determination on sentencing prior to giving the parties and defendant opportunity to be heard, it seems proper at this juncture to make known the court's inclination to not impose any sentence of incarceration a sentence authorized by the conviction, but one the people concede they no longer view as practicable recommendation, as a practicable recommendation. Can you help me understand what that means? Is that essentially saying that prosecutors aren't pushing for jail time, so it's not on the cards?
That is absolutely what it's saying. It's saying that, there could have been incarceration as a potential sentence for this, but their inclination is not to go that route, that the prosecutors are no longer trying to recommend this as the outcome of the sentencing. So the judge is clearly laying that out before we hit the sentencing date now.
So what does that mean in terms of options that would be at his disposal? I know that you mentioned a fine, community service. Can you please just reiterate what some of those options would be?
Sure. It looks like they're saying potentially there would be an unconditional discharge as the most viable solution. So that might mean that they will leave him with, no conditions on his sentencing. But there are, some of the options that I mentioned before are the possibility of probation. Of course, there was incarceration, although it seems very unlikely that that is going to be happening, given what we just read. There also are things like community service. I also don't see that happening in this case. And then there are monetary fines. So that is a possibility as well, although they would be rather nominal, especially for someone like Donald Trump.
Katrina, hang out with us because I believe that we have Jessica Levinson back. Jessica, CBS News legal contributor and Loyola Law School professor. Big breaking news here, sentencing January 10th. But as Katrina and I have been discussing, doesn't sound like the judge is inclined to oppose any kind of jail time. What is your analysis and reaction to this?
I think before the election, after the election, we're not going to see any jail time. Let's remember what type of conviction we're talking about here. We're talking about the lowest level felonies in New York. That doesn't mean that these aren't serious. It doesn't mean that they're not felonies. It means that we're talking about the lowest level felonies. And even if we were having a discussion, as you and I, Lindsay, have talked about Donald Smith as opposed to Donald Trump, I think what we all need to remember is it's not at all guaranteed that you would see any jail time. And again, I know this sounds strange to people because we're talking about criminal convictions. We're talking about felony convictions. Of course, you would have jail time. And the answer is not always. So I think for people who are watching at home, it feels like, well, maybe again, some people feel like this was just a politically motivated prosecution. Other people might feel like, well, here's the president of the United States again standing above or outside of the law. And I just want to situate all of us to say there was no guarantee of jail time for a conviction like this anyway. I think the reason that there was the greater possibility of jail time, frankly, is based on Donald Trump's behavior, the aggravating factor of going after the judge, going after the staff, of the way he conducted himself. But these are nonviolent felonies. And even before the election, I think there was not a big chance of prison time. After the election, almost zero chance of election time. Given the fact that the sentencing is happening on January 10th, a sub-zero chance of prison time.
Can you help us understand the judge's reasoning in scheduling the sentencing for 10 days before Inauguration Day and not, for example, waiting until after the completion of his next term?
So I think you need something extraordinary in order to say we're going to push this an entire presidential term. Now, look, delays are not unheard of. Certainly in the criminal justice system, sentences are delayed because there are medical issues, there are personal and professional issues. But delaying a sentencing an entire presidential term, again, you need to have a good reason for that. And I think the judge was just not convinced that that was there, that when you look at the interests of justice, there just wasn't enough of a reason to say we're going to wait 4+ years. In addition, and you may have already talked about this, forgive me, but the sentencing means that the clock for now Trump can continue with the appeals does not stop. He's sentenced, he's convicted, he's sentenced, he can appeal. And there are live appellate issues that are already being reviewed in this case. I mean, one of them is the theory of this case. And again, I don't know how much you've talked about this, but this was a pretty novel theory. The idea that business records and the falsification of business records could lead to felony convictions. And the theory was really that the business records were falsified in order to commit or conceal another crime. And the prosecution had kind of an interesting theory on what that other crime was. And they basically said it's campaign finance violations or it's tax law violations, but they did not require that the jury all came to the same conclusion as to what that other crime was. They just all needed to be convinced that there was another crime. All of which is to say, I absolutely think there are live issues on appeal here.
Can you help us understand what that would look like? I mean, is there a chance that his legal team could, and look, Jessica, you're the law professor here, not me, could appeal to the Supreme Court, put an appeal in and say, we need to stay on this sentencing while we're asking you to decide the merits of this, given that legal theory that was used as the basis for prosecution?
This is a great question. And everybody, I think, particularly when it comes to these, Trump legal issues, thinks, could this go to the Supreme Court? But let's remember that to go to the Supreme Court, you need a federal question. And when it comes to this case, we're talking about a state prosecution. And I think it is more likely that you would see an appellate issue go up to the state Supreme Court. And the question would be styled or look something like, can a state prosecution continue under the theory of falsification of business records? Can you bump that up to a felony in New York based on the idea that the records were falsified in order to commit or conceal another crime? And is it okay if the jury isn't forced to come to a conclusion about what that other crime was? That all sounds to me like very much a question of, in a New York State criminal case, can you do this? Now, is it possible that the Trump team would try and find a federal question? Yes, but again, it's a state
Jessica,
criminal
I have
case.
to interrupt you because we're going to go to a CBS News special report.
This is a CBS News special report. I'm Major Garrett in Washington. Good afternoon, everyone. We're coming on the air with breaking news. President-elect Donald Trump has been ordered to appear for sentencing in his New York criminal prosecution case on January 10th, just 10 days before his presidential inauguration. Trump was convicted in May of last year on 34 counts related to his hush money payments to Stormy Daniels in the lead up to the 2016 election. It's worth noting the president-elect's legal team had suggested that conviction be thrown out in light of a Supreme Court judgment on presidential immunity. Judge Juan Merchan was reviewing that request for those convictions to be thrown out in light of that Supreme Court ruling on presidential immunity. Judge Merchan concluded, however, that presidential immunity for a sitting president does not extend to a president-elect. I want to bring in our congressional correspondent, Scott MacFarlane, who followed the trial closely. Scott?
Yeah, pretty telling argument here from the judge in this release, in this court filing. Judge Merchan says in so many words that he is ruling out a period of incarceration, sentencing Donald Trump to prison when this sentencing happens. And he explains his rationale, although he acknowledges it's premature to say this before the hearing, but he says even though a sentence of prison would be warranted in this case, that the government and he acknowledge it's not practicable for a forthcoming president to be facing a prison sentence. What's more, he says, according to this extended filing by the judge in the case, that he is concerned about the mental and physical well-being of a president-elect in the final days before the president-elect takes office. He is making some very practical notes as he orders this sentencing hearing so as to make clear Donald Trump is not going to face a prison sentence here when the sentencing is finally handed down.
And Scott, is there some discretion that the president-elect can exercise as to how he may appear?
Yeah, we're trying to fix down on this right now, Major, but there is the possibility of a virtual appearance. Some courts have this when there are extenuating circumstances for a defendant. You can appear virtually, almost by Zoom, the way you would for a meeting, and appear that way in the courtroom if it goes forward as now scheduled next Friday. This really is a coda, though, isn't it, Major, for the criminal cases Donald Trump faced? The one dismissed here in Washington, D.C. for alleged election interference, the one dismissed by the judge in Florida Florida for classified records, alleged misconduct with those, and now in New York, where he was found guilty by a jury on 34 felonies. The clock has worked in his favor. There is no time for Judge Merchan, according to what he spelled out today, to issue a prison sentence to a president-elect of the United States.
Scott McFarland, thank you very much. CBS News investigative reporter Graham Cates has been following this investigation and the case from the start. He joins us on the phone. Graham, your impressions?
I think that there was really only one other option for the judge here if he wasn't going to dismiss the case outright, which he said he wasn't inclined to do, and that was postponing this all the way until after Trump's presidency in 2029. And that was a suggestion made by prosecutors, something for him to think about. But given his inclination here to not impose a sentence of incarceration and his conclusion that a president-elect is not above appearing in a local courtroom, this was really probably his only option. And with such a short window before inauguration, he has very little choice but to schedule it next week.
And Graham, that would suggest that those who look at the trial and the conviction as accountability for a misdeed, the judge is saying the accountability is limited because we have a president-elect who's about to take office, but one procedural aspect of accountability can be an appearance.
Yeah, that's exactly right. There's no circumstance where the defendant can skip sentencing altogether. And in fact, he can't appeal his conviction until after the sentencing occurs. So there's some value in having this happen for President-elect Trump himself. But Scott noted that Trump has been given the opportunity to appear virtually. In a New York courtroom, that's extraordinarily rare. It's really an option given to defendants who are in the hospital, who are unable physically to appear. But here, because he's the president-elect, because his whole entourage, the Secret Service, all of these factors that go into it, the security around the courthouse, they've actually on a few occasions given him this option, and he's exercised it once.
Graham Cates, thank you very much. Senior White House and political correspondent Ed O'Keefe is in West Palm Beach traveling with the president. Ed?
Major, no reaction yet from the Trump camp. There usually is a statement in response to legal developments like this, but nothing as of now. The White House or the press pool that monitors his movements here in the Palm Beach area noted just a little while ago that he's en route back from his golf course, which is about 10 minutes behind our cameras, to his home at Mar-a-Lago. That's in keeping with the usual daily cadence of going to the golf course to spend time there and then go home to Mar-a-Lago. So we'll see if we hear from him at some point in the evening now, either in written statement or other ways in response to this. Important to point out that in this ruling, it looks as if the judge is calling for what's called an unconditional discharge, which is essentially releasing the president-elect with no further obligations or responsibilities, but would essentially still consider Trump a convicted felon in the eyes of the law, or at least in New York State, in this state case. Just reiterate what Graham said there a moment ago. He can appeal the judge's decision denying the motion to dismiss the charges, but he cannot appeal the convictions themselves until after he's sentenced. So there's still a chance that Trump here in the next few days will try to appeal what the judge is asking for with that appearance next Friday. But the substance of those 34 felony counts still not up for conviction. And notable that this is an outgrowth, as you pointed out, of that Supreme Court decision on presidential immunity. What the judge is saying in this case is what the Supreme Court said about presidential immunity doesn't apply to his actions in this so-called hush money case. The other thing that the judge calls out in his ruling in the footnotes is concerns about language used by the president-elect's defense team over the course of the trial, resorting, as he says, quote, to language, indeed rhetoric, that has no place in legal pleadings. For example, countless times in their motion to dismiss, the judge said, counsel accuses the prosecution in this court of engaging unlawful and unconstitutional conduct. Says that could have a chilling effect on judges, something even the Chief Justice of the Supreme Court in recent days has said is causing real problems across the entire American justice system. So we await comment from the Trump team, but obviously not the kind of thing the president-elect wants to be spending his time doing in the lead up to his inauguration. Major.
Certainly interferes with transition plans and inauguration planning. Ed O'Keefe for us in West Palm Beach, Florida. Thank you very much. To reiterate the breaking news, President-elect Trump's bid to toss his hush money conviction has been denied. He is now scheduled to be sentenced January 10th in New York, just 10 days before inauguration. But the judge significantly has indicated Trump will not be sentenced to any time in prison. Our coverage on this will continue on CBS News 24/7, your local news, and tonight on the CBS Evening News. This has been a CBS News Special Report. I'm Major Garrett. Good day.
And we continue to follow the breaking news. A New York judge who rejected President-elect Donald Trump's argument that his criminal case should be thrown out over the Supreme Court's immunity ruling has rejected his motion to dismiss. Now, Trump was hoping to clear his record of 34 felonies before returning to the White House, but Judge Merchan has ordered Trump to appear for sentencing either in person or virtually on January 10th, just 10 days before his inauguration. Let's go ahead and go to CBS News congressional reporter Scott MacFarlane right now. Scott, what are some top lines from this motion?
The judge makes clear, though he is ordering a sentencing hearing, that he is not in position to issue a prison sentence to Donald Trump, despite the fact that such a sentence could be warranted on those types of felony charges, according to the judge's order. He makes a few references and arguments as to why he's not inclined to issue a prison sentence. First of all, saying it's just not practicable to sentence a president-elect to prison, and also saying that the government has acknowledged as much. The prosecutors have acknowledged as much. What's more, he says there is a warranted concern for the mental and physical well-being of the nation's president-elect, recognizing the burden a sentencing with the prospect of prison would have. But I think what's noteworthy here is what's not contained in the language from the judge, in particular, that the clock has so very much worked in Donald Trump's favor in all of his legal cases, including the one which a jury returned a guilty verdict. There simply wasn't time for Judge Juan Merchan to navigate this before the election, and that has certainly changed the complexion of the situation now that Trump has been elected.
So, Scott, there's part of his footnote that I want to read to you that our colleague Graham Cates pointed out. It's a footnote on page 2, and Merchan criticizes Trump's attorneys and cites Chief Justice Roberts' year-end report. And he writes, counsel has resorted to language, indeed rhetoric, that has no place in legal pleadings. For example, countless times in their motion to dismiss, counsel accuses the prosecution and this court of engaging in unlawful and unconstitutional conduct. These same terms are also peppered through defendant's reply. Those words, by definition, mean criminally punishable. He goes on to say that such arguments in the broader picture have the potential to create a chilling effect on the third branch of government. Judge Merchan, in all these proceedings, has been very cognizant that this is a politically charged issue. He has tried to remove politics from his courtroom. Can you expand on that, please?
That's always been an aggravating factor for Donald Trump in this case, and always why the risk of prison time might have been a little bit higher for Donald Trump. The judge had repeatedly castigated Trump or defense lawyers for their conduct in this case, for their language at times, for their adherence or lack of adherence with his orders and his courtroom procedures. I think you see that in the footnote. Again, Judge Merchan criticizing how the attorneys are conducting themselves and the language they're using in the context of this case. When you go to a sentencing in a criminal case, be it local or federal, judges consider any number of things, some of them required criteria for when determining the sentence. But when defendants or their lawyers seem to be in the contempt of the court or not recognizing the authority of the court, that could be an aggravating factor, which raised the prospect of Donald Trump going to prison on a fraud case. That possibility seems to have been eliminated now by his election and by the calendar.
Thank you so much, CBS News congressional correspondent Scott MacFarlane. Let's go to CBS News senior political and White House correspondent Ed O'Keefe in West Palm Beach. Had a busy day in your world. I know you're tracking closely any reaction from Trump and his team. I'm guessing we haven't heard anything yet.
Your guess is correct, Lindsay. Nothing yet. We should anticipate something at some point, but as of yet, no response from aides and no statement posted. That could change at any moment. He is back, or he was en route back to Mar-a-Lago, his home from the golf course just a short time ago, and is expected to be here through the weekend. And so we'll see if we get some kind of a response or perhaps even an appeal of this order to appear either virtually or in person next Friday in New York. And it's important to remind people as they tune into this news that he can appeal the judge's decision denying the motion to dismiss the charges, which is what this latest ruling is in response to, saying, no, we're not dismissing the charges, show up for sentencing next Friday. What he cannot do is appeal the 34 felonies, the actual substance of the conviction just yet. The other thing is, if you read this ruling, because if you're watching, you're thinking to yourself, does this mean that the president-elect is going to jail? No. The ruling makes clear that that is not on the table. And he talks about what's called an unconditional discharge, which in legal terms is essentially a release in which the president-elect has no further obligations or responsibilities, but in the eye of the law is considered a convicted felon. So that doesn't go away, and he gets inaugurated as a convicted felon, our first American president who was a convicted felon. That appears to be now on the verge of happening. Let that be a moment in history, but it won't mean anything for him functionally day to day, and it's not like there would be something like a sentencing awaiting him at the end of his presidency. So we'll wait and see if we get some sense of a response. Nothing yet, and obviously not the way he wants to be spending the last 17 days before he's inaugurated president yet again.
And of course, we're going to dive more into the legal arguments and all of the different avenues that this could take. But I want to stay with you for a second on the politics of this, because virtually all of the statements that we've gotten from Stephen Chung, one of his communications specialists, is that the American people, this is his words, overwhelmingly gave Trump and Republicans a mandate, and that they use the ballot box to say that they are not happy with the way the Justice Department and the FBI are currently operating. I can imagine that those are some arguments that we are going to continue to hear from Trump world.
Sure, but a judge and lawyers, prosecutors would turn around and say, that's great for your political future, but this is a legal matter. And legally, you have to show up for this sentencing and face the music. And, they have a point, because the question, of course, we've been asked ad nauseum for the last several years is, what effect will this have on him politically? Well, it's had none. If anything, it's only boosted his standing politically and buoyed his support among fellow Republicans who believe that the Justice Department, or wheels of justice across the country at the local, state, and federal level, have been misused to go after him. And in fact, there was an argument he was making. What were we talking about this 2 days ago, Lindsay, in the wake of the attacks in New Orleans and Las Vegas? If the Justice Department hadn't been focused on these things, maybe they would have been rooting out Islamic terrorists, and that attack in New Orleans wouldn't have happened. It's a political argument that prevailed in November that remains quite popular with his base, and that has had, all of this has had little effect on his political standing other than to boost his support among supporters. What it'll do for detractors is just reinforce why they didn't like the guy to begin with, or why they didn't want to see him back in office, because they just don't like the idea that a convicted felon is going to become president.
Ed O'Keefe, thank you so much for your reporting and analysis. Appreciate it. Let's go to CBS News investigative reporter Graham Cates. Graham, you're joining us on the phone, and you've been emailing us significant parts of the motions that really stick out to you. What can you tell us about our viewers of some of the top lines of this motion from the judge?
Sure. I think you've hit on the main thing already, which is that he concluded that the president-elect of the United States doesn't have the same constitutional responsibilities and rights as the president himself, and that's why there's no avenue for him to avoid sentencing in this matter. And the timeline was short, so they scheduled it for just 10 days before inauguration. But I want to note the judge, Juan Merchan, took some time in the footnotes to kind of criticize Trump's attorneys. He said that their rhetoric changed from what he called spirited before the election to coming dangerously close to crossing the line, that's his words, after the election, where they accused the court and prosecutors of unlawful or unconstitutional behavior. And he said that rhetoric is dangerous, and he cited the Chief Justice of the United States' end of the 2024 year-end report in saying that this kind of rhetoric from elected leaders is dangerous for the judiciary and for the independence of the third branch of government.
And per the first part you were talking about, I'll go ahead and read that excerpt in which the judge says it seems proper to make known the court's inclination to not impose any sentence of incarceration, a sentence authorized by the conviction, but one the people no longer view as a practicable recommendation. Graham, I want to ask you, did this come as a surprise to you, considering that there were a couple of other options on the table from DA Alvin Bragg, including treating this case like they would with someone who is deceased in terms of having the conviction stay but not imposing a sentence, or waiting for sentencing until after the completion of the next term. Does it surprise you in this world that you're steeped in that we will now see a sentencing barring any other events on January 10th?
Surprise might be the wrong word. I think that their motions, their prosecutors' motions, acknowledge that jail was increasingly a hard outcome to picture because of Trump's election. The suggestion that it be put off for 4 years until after his presidency was one that would maybe only be worthwhile if jail were in the cards. But he can't appeal his conviction until after sentencing. So this is kind of a good middle ground where he's able to continue to pursue his rights as a defendant while he's president. But the whole country isn't left waiting for 4 years to find out what's going to happen with his case. And he, as a defendant, doesn't have to wait that long either. He now knows that on Friday he's set to be sentenced. He's not going to be sentenced to jail time, that's off the table, and he can move forward with his life. And the case, at least the part of it that involves this local court in New York City, can move on.
Graham, I'm going to throw you a curveball before I let you go. And the man on the right side of the screen, this is Todd Blanche. This is Trump's attorney in several of his criminal cases, including this one, the falsification of business records related to payments made to Stormy Daniels, which Trump denies. Todd Blanche has been picked for Trump's deputy attorney general. So again, this is a curveball, and I don't know we know the answer yet. But is it likely that his legal team will take new shape, given that he has nominated Blanche to that position?
Yeah, at some point it will have to. Right now, Todd Blanche is his personal attorney, and Emil Bove is also going to the Justice Department from Trump's New York defense team. So in order for them to be, the Department of Justice doesn't argue in local New York courts, and not for private criminal defendants. If the question is, will the Justice Department at some point get involved? But if after New York's whole court system, all the way up to its highest court, which is called the Court of Appeals, works its way through this case, and they move on to appealing it to the Supreme Court, for instance, that might be a different matter for the Justice Department. But the Justice Department is not typically involved in state criminal matters, so it's reasonable to expect that there will be some new faces involved after Trump becomes president for his local criminal defense.
Graham Cates, thank you so very much. Let's go to CBS News reporter and lawyer, attorney at law, Katrina Kaufman. Katrina, good to see you again. I understand that you have an excerpt of the motion that you would like to dive into a little bit. Go ahead and tell us what you've identified as a significant part and why.
Yeah, so on page 7, Lindsay, there's an interesting passage where Judge Merchan points out that Trump is now saying that there's too much of an undue burden on him to be sentenced before he goes into office during this period between the election and his inauguration. But what Judge Merchan says is that this is actually what Trump asked for. He said that he wanted the sentencing, which, as we discussed earlier, was originally set for September, to be moved to after the election so that it would potentially influence the election results. So Merchan writes, while defendant now claims this court cannot and must not sentence defendant, the record is clear that defendant not only consented to, but in fact requested the very adjournment that led us down the path that we are on. And he says any claim defendant may have that circumstances have changed as a result of his victory in the presidential election, while convenient, is disingenuous, says Merchan. So he really points out very clearly here that Trump asked for the adjournment, and that clearly if he was elected, which he also says that Trump was always very confident that he would be elected into office, that he had to know that the sentencing would need to take place during this period. Also, as you were just talking about with Graham, I mean, he also points out that really to serve all interests and bring some finality to this, he needs to do the sentencing before Trump's inauguration. And again, he says that Trump has always made it clear that he wants to use every appeal that is available to him. And he really can't do that until after the sentencing. He cannot appeal this conviction.
So what could happen given that it sounds like jail time's not on the table?
So as you were discussing earlier, what the judge is saying is it looks like he's leaning towards what's called unconditional discharge. And under New York law, that means that Trump would remain a convicted felon, but he would be released without any terms. So there would be no imprisonment, there would be no probation, there would be no fine. So it's looking like, according to this, that's what the judge is leaning towards now. He is making it clear that he is not going to serve Trump with jail time. But another thing that I don't think we've talked about yet that could be interesting at the sentencing, if Trump decides to do so, is that a criminal defendant is allowed what's called allocation. They can speak on their own behalf at the sentencing for a criminal trial. So often this is the moment where a defendant might choose to express remorse, to explain what happened, provide details that maybe aren't in the probation report. As we may recall, Trump decided not to testify during the trial. So it is possible that this could be a moment where we hear Trump himself speak about this case if he chooses to do so.
Katrina Kaufman, thank you as always for your analysis. Let's bring in CBS News legal contributor and Loyola Law School professor Jessica Levinson. And Jessica, I want to ask you, I kind of want to hone in on one thing that Katrina had said, and that is that if there is a sentencing, I believe she said conditional, where under New York law, the conviction would stay, he would be a convicted felon. What, if any, effect would that have on Trump's day-to-day life if he is walking through life holding on to that felony conviction?
I think very little. So let's be clear that under the Constitution, any person who is convicted of a felony can still be the president of the United States. Small caveat here, there's of course that continuing question under Section 3 of the 14th Amendment as to whether or not related to separate actions, specifically January 6th, the president is barred from being president again. But Lindsay, to your excellent question, it's unconditional sentence. It's a conditional sentence. It's a fine. I think anything short of you will be incarcerated for some period of time after January 20th, which we knew wasn't going to happen, anything short of that really will not be an impediment to President Trump's ability to function as president.
I mean, would he be able to, for example, vote in the midterms? I mean, some states have restrictions, but others say after you completed your sentence, you can vote. And if there's no sentence.
I'm going to go based on memory here, which I believe is always dangerous to do on live television. But
Amen.
We're talking about somebody who is registered to vote in Florida. And the question as to whether or not a convicted felon, because there's no question about the conviction and whether or not it will stand. It will stand. And what I believe is that last time this question came up, the answer is that Florida refers to the law where the person was convicted. And under New York law, based on these felony convictions, you could still vote. And so Florida is going to refer back to New York. New York's going to say you can vote. And so Trump in Florida could vote. So I think that's the answer to that question. But it reminds us that we've never been here before. We've never been in a situation where the president is a convicted felon. And we're having conversations like, what if he was on probation? What if he had, which he won't, let's be clear, based on this particular memorandum from the judge, what if he had an ankle bracelet? Like, what if? I think the answer for everyone tonight is, one, that the conviction, according to this judge, should stand, that there was plenty of evidence to support it, that nothing the Supreme Court said and nothing about the election will change that, and that there will be no jail time and, frankly, no significant punishment. That the punishment, which, frankly, may not be particularly impactful for President Trump, is that he will forever be known as a convicted felon.
Jessica Levinson, thank you so much, as always. And while we've been talking, we did just minutes ago get a response from Communications Director Stephen Chung on behalf of Trump, saying, quote, today's order by the deeply conflicted acting Justice Merchan in the Manhattan DA witch hunt is a direct violation of the Supreme Court's immunity decision and other long-standing jurisprudence. This lawless case should have never been brought, and the Constitution demands that it be immediately dismissed. President Trump must be allowed to continue the presidential transition process and to execute the vital duties of the presidency unobstructed by the remains of this or any remnants of the witch hunts. There should be no sentencing, and President Trump will continue fighting against these hoaxes until they are all dead. Just one note, because they did mention the immunity decision, and as we've been discussing, the judge did mention in his motion that he did not find any of Trump's legal arguments to be a compelling reason why the immunity decision would have applied in this case. He said that these acts were unofficial acts and therefore not protected by presidential immunity. We do have other news we want to get to, and law enforcement in Las Vegas gave an update on the deadly Tesla Cybertruck explosion in Las Vegas. They say the soldier who died in the incident left a note calling it a stunt and saying it was to serve as a wake-up call for the country. Here's some of what we heard from police this afternoon.
First one of those priorities was to confirm that there's no further threat. I think we've completed that. The second was to positively identify the suspect. We've also done that today. I can confirm that that is Matthew Livelsberger. We also wanted to confirm that there were no other actors